or a little more time, you can take it out of the 5, and then that way you'll have some time for rebuttal if you want to use it. Or I want to make sure you get your full amount. I don't want you rushed on this.
I don't think my brain has it in me to rebuttal anything.
All right.
It's written down.
Yeah. Okay. So,
Just
all right, go ahead.
fire the gun when you're ready.
Yeah. Now, again, I'm sorry our speaker system is not working today, so the microphone not working. So we're going to ask both sides to kind of speak up.
Can you hear me so far?
Yes, ma'am. And if we can't, we'll tell you, because we need to be able to hear you.
And I want this little doohickey right here.
Yes, that's your timer. That'll tell you the time. Okay? You can start when you're ready.
First off, I want to say that everything I have in evidence, knowledge, memory, research, I have already sent in my brief and my oral answers. And I tried to be as explicit as I could be in those because I had heard that it was going to only be 15 minutes. There's no way you can get all that information in 15 minutes, and you always forget something. And so I wanted to make sure I got it down on paper and got it to you. There was a couple things that stuck out that I feel needs to be made sure that your honors know for sure who Furman R. Raines was. He was the heir to Isaac and Dora Raines, who owned the property that recently sold in Tennessee. The reason why I bring this up is because I don't know what the Bateses have told that happened in the family, but I'm going to read this. And so if it doesn't sound right, it's because I wrote it when I was thinking about telling this to you. And I write, I need to make sure this court knows who we are talking about. I don't know what story the Bateses are telling to convince 2 lawyers that my dad's last name was Bates. Jeffrey Green of the Chancery Court, attorney overseeing the locating of heirs and the sale of land. Mr. Green refused to talk to me in the beginning. Finally, one time he did. He said that Judy Bates had a will given to her. All right, Judy Bates had a will from my dad, leaving everything to Judy. Mr. Green read the will, and I do refer to this will in my writings. I leave everything I own to Judy Bates, signed Alvin Bates, which is her brother. That will was written back in the 70s. It was because he went in for emergency heart surgery. She just kept it all those years. I told Mr. Green, my dad's name is Furman Raines, and he had no will. Mr. Green and I talked, and he told me he and I were cousins. Mr. Green and I are related. I'm not sure why he's in this Chancery case. Mr. Green, being family of the Raines family, should have known my dad's name was Furman Raines. After I explained the situation between myself and the Bateses, Mr. Green said it sounds like the Bates need to hire a lawyer and prove they have a right to a share of the sale of the property. Then there is Michael Thomas. I'm assuming that's you. Who's Michael Thomas? He's the attorney, right? Okay. Then there's Michael Thomas on page 9 of the brief of the appellees, the decree of equitable adoption, which also lists the appellant, Marilyn Troutman, as present during the hearing, orders that the appellees, Gary Bates, Paul Bates, Judy Bates, are the lawful heirs of Furman Bates. No mention of Alvin Bates. My father's name is Furman Raines. In Mr. Thomas's brief, he refers in footnotes and statements. He has all these letters concerning adoption. I was not able to find this information to respond to it. I don't know if the court has received it. I did not receive any of it. I have written in my brief and oral answer all the information and evidence I have. I am sure I will forget something during this hearing. I can't understand how a man who was dead a year adopts grown adults. 6 months before his death, he never offered to. This equitable adoption is fraudulent, and fraud is one of the reasons to consider this adoption invalid. And there's a Capita Partners Network, OT INC 622 SW. Tennessee does not recognize equitable adoption. Craig versus Garner, 1969. Tennessee does not accept equitable adoption even in the state of Tennessee. I put stuff in there, case laws concerning what I found about adoptions in Missouri, whether they're legal and what I have found in the state of Tennessee. And in my mother's own will, she said that she was not holding my father to some kind of equitable options upon her death. And she left everything to my father when she died. And it was up to him to do what he wanted with it. He lived 6 months after my mom died. Not one time during that time did he ever attempt or even suggest that he was going to adopt the Bateses. That's all I have.
Okay, I hear no questions, so
Say it.
we don't have any questions right now, so.
Should I sit down?
Yes, if you can sit down at that table, please, and if you want to, you have time left, so if, after he goes, makes his argument, if you want to.
Can I assume Mrs. Victor Thomas? Well, you announced who I was, so I just thought.
Well, he will. We'll require him to. He's required to announce his name. But after he finishes, if you want to say something else, you're allowed. You still have some time to do so. Okay, we'll hear from you.
May it please the court, good afternoon. It's an honor to be before you again here today. My name is Michael Thomas. I'm with the Hamilton County Bar. I'm here representing the appellees, in this case, Gary Bates, Paul Bates, and Judy Bates. This case is a partition action in which they're seeking to clean up color of title among about 73 potential heirs at law in this case. So I do not envy that task down at the trial court attempting to unwind that. We're here today on this appeal, and respectfully, I'm not entirely positive what we're here to discuss. Rule 27 states that there must be issues presented to this court, and that this court isn't to tease out the appellate issue that's being brought before you, or to argue it or locate the research on behalf of the appellant. In the appellee's brief, we attempted to identify what could possibly be the issue. However, it's difficult for the appellees to make that determination for the appellant, respectfully. A number of cases out there that discuss the failure to follow and apply Rule 27, specifically A1 through 8. And in this issue, that's what we have before the court. We have no citations to the record. We have no transcript. We have no case law. And the first time any case law was mentioned and was brought up in the reply brief as sort of new issues after the fact in responding to the appellee's brief. Respectfully to the appellant and to this court, we would ask the court to consider that the appellant has waived her arguments for the failure to follow Rule 27 for the issues that I've previously discussed. With respect to the lack of a transcript, any factual issues brought before this court are difficult to reconsider without knowing what occurred down at the trial court. In the instance here, we have no evidence other than an order that seemed to approve a special master's report. We don't know what arguments were made down below. We do not know what facts were considered. Accordingly, this court has found that the presumption should be upheld that the trial court was correct in considering these facts, if we are to make it past the waiver stage, Your Honors. The only issue of law that might be before this court is the application of full faith and credit. This is an issue that does not appear to have arisen down in the trial court. Having reviewed the 200-plus pages of record that were provided by the trial court to this court, I was unable to locate any mention of full faith and credit. We have a Missouri order. We have a Missouri order that was consented to by the appellant, granting my clients, ordering that my clients were in fact the heirs at law and natural issue of Furman Reigns. Now, I understand the appellant's argument is that since they don't share the same last name, they're not related, but based on adoptive legal reasons, that's just not the case. In fact, it appears that the appellant is attempting to relitigate the Missouri order before this court, which, as Your Honors are aware, is not proper. That is an issue best remedied over back in Missouri before the same court. Any attempts to argue it down at the trial below, we would posit, rests with full faith and credit. Attacking whether this order, or the court who handed down this order, had subject matter jurisdiction, personal jurisdiction, was there fraud involved? And on those three issues, the statutes say that that particular court has the ability to determine who the heirs at law are. So subject matter jurisdiction and personal jurisdiction appear valid, especially in light of the fact that the appellant signed a settlement agreement and consented to the entry of the order which named my clients as the heirs at law and natural born heirs of Furman Reigns. With respect to, with respect to fraud, I haven't seen any specific misstatements of fact upon which anyone attempted to rely. I don't think there's anything there, respectfully. Public policy, however, the appellees can see where an invalid order might come across as a potential for violative of the public policy argument. Now, while Ms. Troutman didn't raise any issues either in her brief or in her reply brief with respect to the public policy issue, the only thing, well, I take that back. In the reply, she mentioned something along the lines of how Missouri doesn't recognize, you cannot adopt an adult without the permission of the person to whom the purported adoption applies. With respect to that issue, there was a statute provided, which is cited in my briefs, Your Honor, that effectively, for lack of a better description, waves a magic wand over any defects. The appellees aren't conceding that there's anything wrong with the order. It was a valid order consented to by the appellant that was executed by the trial judge in this case. However, the statute does say that any issues prior to the entry of that statute will effectively be, we're going to say it's okay, and we're going to uphold those adoptions. This appears to be Missouri's attempt to sort of standardize the adoption process under a new set of laws, and instead of going back and potentially relitigating a number of orders that had been entered over the previous decades, they just said, look, whatever happened before is fine. We are going to effectively state that those orders can no longer be attacked. And moving forward, we're going to apply these new sets of laws as to how the adoption process is going to proceed. With that consideration made by the Missouri courts, I don't see any public policy argument that could prevent this order from being considered either by the trial court or this court, Your Honors. I don't really have much to say after that because there's a lack of direction here, but if Your Honors have any questions for me, I'd be more than happy to entertain them at this point. Thank
I
you,
hear
Your
none.
Honors. I appreciate your consideration of this matter.
Thank you. Ms. Troutman, would you can use some time for rebuttal if you'd like to.
Well, I mentioned this and that I saw footnotes, references to letters, and he mentioned it again, that papers were submitted concerning the adoption and stuff concerning, and I never was given any of this. And I'm representing myself, and I feel if I'm representing myself, that I have the same rights as an attorney representing his clients. So if he had all this evidence that he wrote about, I should have been given that same evidence so I could reply to it. So I don't know what you have that I don't have. And one of the major frauds in the equitable adoption is that Judge Story was the presiding judge over that equitable hearing that took place. And I write to you about how Mr. Thomas made light of me being tired after my parents both tragically died 6 months apart. I was suffering mental illness, and I wrote about it, and I told you about it in my answers. And I hired an attorney to take care of this. And Judge Story presided over the case, and he said he would take it into consideration. But Judge Story didn't sign it. Judge Arthur Cohen signed it. I don't know how one judge can hear the case and another judge who's not even in the building at the time can sign off on it. It's a new one to me. And I believe the reason that Judge Story didn't sign it is because he was a friend of my dad's. And I think he could see what was going on. And I think he just decided to walk away. He was a longtime family friend, and he didn't want to get in the middle of it. So he just let it ride until he was going to decide. He has the right to decide when to sign that paper. Lawyers don't tell him what to do. But then all of a sudden, here comes another judge. He signs it, and it's in there. I call that fraud. And I don't believe, I thought I read this, that people, Paul and Gary and Judy and Butch, they were in their 30s and 50s. And you're telling me that my dad, who was around, you read the history, I wrote you a history starting in 1957. Butch and Judy were practically out of the house when Mom and Dad got married. And Paul and Gary were raised on Social Security from their dad. My dad was not much of a father. He was a bachelor till he was 39. He didn't even take care of me and Mike. And you're saying this man offered to adopt Paul and Gary and Judy and Butch when he had 6 months after my mom died to do it? That ain't the Furman Reigns I know. I'm just saying that there was things that was wrong. I apologize for not having enough guts to be able to stand up after losing my parents, but I would have just rather died. If they wanted all that stuff, fine, take it. But now it's all these years later. And the one last thing, and if you read in my mom's will, she said any property that's sold out of state, and I know she's talking about the property in Tennessee, my dad bought all that property before he married my mom. And she said that when it sold, she wanted the money to go to her executor, which was me. I just want one last time just to get out of the situation without being taken advantage of. Now, you might think I was just being tired and overworked, Mr. Thomas, but, I don't know how long you had your parents.
Ms.
I was
Troutman,
29 years old.
talk to us, not to him.
I know, but I was 29 years old. My whole life was destroyed. I have no kids. I have no family. My husband divorced me.
I wasn't tired, I was scared, I wanted to die. That's all I got to say. That's all I got to say. I want to go sit down, please. Can I please go sit down, sir? Let me explain to you how the process goes from now, so you'll know you can sit down or stand up, whichever you want. How the process proceeds from now. We'll take the case under advisement, and then we'll reach a decision, and we'll prepare our decision will be put in writing, and we'll send it to both of you at the same time, and you both will be notified at the same time of our decision. Okay? Do you have any questions about the process? Not about how we're going to decide, but about how the process goes. Okay. After we recess court, you take your time you need to gather yourself here. You don't have to leave immediately. So just take the time you need. If you would, please adjourn court till 9:30 tomorrow morning.
All rise.
You're fine.